This video has been prepared for general information purposes only. The information is not legal advice. Legal advice is dependent upon the specific facts and circumstances of each situation. The information contained in this video cannot replace the advice of a competent, licensed attorney. You should be sure to consult an attorney in your area to discuss your particular case.
Hello, I'm Tamika Cannon. I'm an attorney at South Carolina Legal Services, and today we're going to talk about what to do if you've been denied unemployment compensation benefits. The first thing that you want to do once you receive the denial letter is to immediately go to your local unemployment office. You must file an appeal within 10 calendar days of receiving the denial letter. You'll want to make sure that you file the appeal in writing and that you keep a copy of your records. It's important that you get a copy of the appeal that you file that has been time and date stamped by the unemployment office as proof that you've met the required filing deadline. Now, you can also ask to review your file with the unemployment office. That's important because it'll inform you as to the reason the employer is alleging you should be denied the benefits. It's a good way to prepare for the hearing so that you'll know what allegations they're going to make against you. You can also see any other paperwork that the employer has already provided to the unemployment office. You can also request that the unemployment office send subpoenas to any witnesses that you want to attend your hearing. Keep in mind that any witnesses that you have subpoenaed on your behalf to attend the hearing, that they will support the allegations you make, that they will present the information you want the hearing officer to have. The unemployment compensation appeal hearing can be a little peculiar in that many of your witnesses will often still be employed with the employer. So it can be awkward or uncomfortable for them to come and provide information that contradicts what the employer alleges happened. So some witnesses may be hesitant or even unwilling to participate in those hearings. So you want to just keep that in mind before you have the unemployment office subpoena those individuals to your hearing, because they may do more harm than good. Now, once you actually attend the hearing before the appeal tribunal, the setup will be there will be a hearing officer present, whomever is there to represent the employer, you of course, and then any witnesses that you have subpoenaed to attend or that you request to be there, and any witnesses that are there for the employer. You want to go to that hearing prepared with any documentation or evidence that you want the hearing officer to consider. The information should be relevant and help support your claim as to why you should receive the unemployment benefits. You'll be given a chance to answer and ask questions of the employer and of their witnesses, and likewise the employer will be able to ask you questions regarding any allegations or information that you present to the hearing officer. The hearing will also be recorded, so you want to keep that in mind. You should also take extra copies of any documents or evidence, actually 2 extra copies. One will be for the hearing officer and one will be for the employer. And of course, you always want to keep a copy of any evidence that is provided for your own personal records. It's very important to keep in mind that the appeal hearing is your only time to present information to the hearing officer. It's your only opportunity to get the facts that you want to be heard and considered in the decision whether or not you're granted the benefits. So make sure if you need to take notes, you take handwritten notes to remind yourself, yeah, I need to make this point to the hearing officer to explain why I should be entitled to the unemployment benefits. If you don't present that information at that time, you can't come back later and present it to the hearing officer. It will simply not be considered. Now, you will get a decision letter after your hearing to the appeal tribunal. You'll normally get that letter within 10 days. It'll be sent to your last known address. And from 10 days of that mailing date of the decision letter, you have 10 days to appeal further if you are again denied the benefits. If you file a second appeal, that appeal will be to the appellate tribunal. Those hearings will be held in Columbia before 3 judges, and at that time you have the opportunity to present a case as to why you should get the benefits. Again, it will be limited to the information and arguments that were made before the appeal tribunal. Now, let's talk a little bit about the requirements to be eligible for unemployment benefits. To receive unemployment compensation benefits in South Carolina, you have to first be eligible for work. That means that you have no limitations or restrictions such as a disability or illness that would prevent you from working. You also have to be actively seeking work, meaning that you're actually going out and making a good faith effort to find employment. You also have to have enough earnings at a previous job or previous employment to draw the benefits from. What if you were fired? Now, if you were fired, you may still be entitled to receive unemployment compensation benefits. That determination has to be made on an individual basis. If your employer claims that you're not entitled to benefits because you were fired, the employer has the burden to prove that you were discharged for cause. To be discharged for cause means that you were terminated or let go due to fault, your own fault, or something that you did wrong. For example, drug use, or if you're absent from work excessively. Those are some good reasons to be discharged for cause. Or say fighting with coworkers. However, the burden is on the employer to prove that you were at fault in those situations. Again, at the appeal hearing, the employer is given the chance to present evidence, say statements from coworkers, or disciplinary reports documenting your misbehavior, to show why you were let go and that it was appropriate. You're given an opportunity to contradict that evidence. You can present your witnesses to show that you repeatedly informed the employer about a dispute that you had with another employee and that you tried to have that resolved, and perhaps the employer didn't take appropriate action to help resolve that dispute. So you're given an opportunity to present your side of what happened. What if you quit? If you simply quit your job, then you are not eligible to receive unemployment compensation benefits. However, there are some exceptions. If you quit, voluntarily quit, it's your responsibility to show that you did so for a good cause that is connected to the employment itself. For example, say your employer significantly reduced your pay or changed your work hours. Those would be valid reasons for you to quit your job, and those are jobs that are related specifically to the employment itself. Under situations or conditions such as that, you may still be entitled to receive unemployment benefits even if you quit. However, again, the responsibility is on you to show that those changes were significant and that they were related to the employment. Situations such as unavailability of child care, transportation difficulties are not considered reasons related to the employment. If you quit your job because, say, you don't have transportation, you would not be eligible to receive the unemployment benefits. Now, there are some special situations that occasionally come up that causes a person to either have to quit a job or to be let go. Now, these are very fact-intensive situations, and if one of these applies to you, you should consult with an attorney to determine whether or not you should appeal your denial of unemployment benefits and whether you may in fact be entitled to those benefits. If your spouse has been transferred due to military reasons, a military transfer, you may be eligible for benefits. If you have to leave your job due to domestic violence, for the safety of either yourself or your family, you may be eligible to receive the benefits. Illness for yourself or illness or disability of a family member. That may be a condition under which you can still get the unemployment benefits. Or if your spouse has had to relocate to another city or state for employment reasons, you may again still be entitled to receive the unemployment benefits. A helpful website to consult is do.sc.gov. That's the website for the Department of Employment and Workforce. They have helpful information, timelines, if you've been denied unemployment benefits. You may also refer to the South Carolina Legal Services websites, which will be mentioned at the end of this video. Well, thank you for watching. I hope the information has been helpful to you, and best of luck in your appeal for your denial of unemployment compensation benefits.